Yes, my intelligent viewers, I brought one very good video for you from criminal law that is meant for intelligent people. The topic is circumstantial evidence. It is generally believed in this type of cases in criminal law that witnesses may tell a lie, but circumstances will not. This is one point. Second point is if the defense, that is accused, gives a false story, false evidence during examination, then what will happen? And the last but not least, if circumstances tell a lie, then what will happen? Now, in Sarad Birditan Sarada versus State of Maharashtra, reported in 1984 for SSC 116, our learned and honorable Supreme Court has laid down 5 golden principles that should be satisfied before a case based on circumstantial evidence against an accused can be said to be fully established. Number 1. The circumstances from which the conclusion of guilt is to be drawn should be fully established. Number 2. The facts so established should be consistent only with the hypothesis of the guilt of the accused. That is to say, they should not be explainable on any other hypothesis except that the accused is guilty. The circumstances should be of a conclusive nature and tendency. Number 4. They should exclude every possible hypothesis except the one to be proved. And the last but not least, there must be chain of evidence so complete as not to leave any reasonable ground for the conclusion consistent with the innocence of the accused, and must show that in all human probability the act must have been done by the accused and only accused, by the accused. The Honorable and Learned Supreme Court in this citation has rejected the contention that if the defense case is false, it would constitute an additional link as to fortify the case of the prosecution. Supreme Court doesn't agree with this. Supreme Court has laid some conditions for that. However, a word of caution was laid down to observe that a false explanation given can be used as a link when there are 3 things suggested by the learned Supreme Court. Number 1, various links in the chain of evidence laid down by the prosecution have been satisfactorily proved. This is the first condition. Second is, circumstance points to the guilt of the accused with reasonable definiteness. It means with reasonable certainty. Number 3, the circumstance is in proximity to the time and situation. If these 3 conditions are fulfilled, only then the court can use a false explanation or a false defense as an additional link to lend an assurance to the court and not otherwise. Thus, a distinction has to be drawn between incomplete chain of circumstances and a circumstance after chain is complete and the defense or explanation given by the accused is found to be false, in which event the said falsehood is added to reinforce the conclusion of the court. This has been said by learned Supreme Court in Judgment 2024, 1 Crime, page number 4, Supreme Court. Perumal Raja, appellant versus state represented by Inspector of Police, respondent. It is true that the underlying principle whether the chain is complete or not indeed would depend on facts of each case emanating from the evidence, and there cannot be straightforward formula which can be laid down for the purpose. It is always to be kept in mind that the circumstances adduced were considered collectively must lead to the conclusion that there cannot be a person other than the accused who alone is the perpetrator of the crime. Now, in circumstantial evidence, competent police investigation officer can reach to the real accused by using his intelligence, by analytical mind, and investigating below the surface. On other hand, a competent advocate can acquit the accused by using scientific evidence and analytical mind, his knowledge, his experience. Now, in this circumstantial evidence, there are certain points for defense lawyer. He can utilize it for the acquittal of the accused in the larger interest of justice. It is now well settled that in a case relating to circumstantial evidence, the chain of circumstances has to be spelled out by the prosecution. It is the duty of the prosecution. And if now the benefit, advantage to the defense lawyer, if one link in chain is broken, the accused must get the benefit of doubt. This is the benefit. Now, second benefit, lapses in investigation. Lapses on the part of investigation cannot be used by the accused to their advantage. This is generally believed. But in a case wholly based on circumstantial evidence, which even otherwise lacks credibility, lacunae left by investigation agency must necessarily operate to the benefit of accused. Defense lawyer can utilize this. Learned Supreme Court has cautioned, human nature is too willing when faced with brutal crime to spin stories out of strong suspicion. The apex court has held time and again that between may be true and must be true, there is a long distance to travel which must be covered by clear, cogent, and unimpeachable evidence by the prosecution before an accused can be convicted. Simply on the basis of suspicion, however grave it may be, the accused cannot be punished. And the last, innocence of accused is presumed till the charges are proved beyond reasonable doubt. I repeat again, innocence of accused is presumed till the charges are proved beyond reasonable doubt. This has been stated in Ramanand alias Nandalal Bharti versus State of Uttar Pradesh, year 2022 SC 5273. Now the last point. If circumstances tell a lie, then what will happen? If circumstances tell a lie, then innocent man can be punished. He can be trapped in false evidence. So, this is a very intelligent topic, intelligent for prosecution as well as for defense. Hope you have enjoyed this video. Enjoy it, share it, like it, and subscribe it to motivate me, to encourage me. I will come with very good videos in the next time. See you in the next video. Thank you very much for watching this video. I thank it from the bottom of my heart.